Thank you. May it please the court? I'm here to present what I believe was a error on a single justice not accepting a 211-3, a legislative intended enactment so that we and anyone in the Commonwealth may address an error in the lower court. This court has the supervisory powers, and there is the case law that I cite in my brief in regards to the position that this court would take, and I appreciate the court taking this position today. Understandingly, there are narrow reasons for this court to take attention on this case, particularly when due process is infringed. Substantive rights of mine have been affected as a result of the single justice not taking the necessary steps to protect those interests. There was the evidence in front of him that was presented for the record, and I supplemented the record with the record appendix. I'm sorry that came in so fairly late, but most of the material was presented, most of all of the material was presented to the single justice, both in the appeals court and in this court. Of course, being at the appeals court, and this single justice denied the reasons, presumably that he thought that I could take this case in a year's time up the normal channels of the appellate process, but under the circumstances of the property, unique property, federal benefits, that could not be accomplished in that length of time. For instance, the federal benefits that I so tried to save in June weren't actually eliminated until December upon a hearing in Kentucky, where a finding was made that I wasn't there. In regards to the evidence that the record appendix contains, I think that this case, as I emphasized, has been incorrectly handled in the lower court. That's on appeal. It's fundamentally unfair that 4 defense attorneys couldn't work, fundamentally unfair that an expert witness was not allowed to be provided to myself. It was fundamentally fair that the fact witness wasn't allowed to present factual evidence of his initial examination of my Persian cats, laboratory tests that would have conclusively proven my innocence, exculpatory evidence like that. What was the judgment of the sentencing judge to eliminate that? It was fundamentally unfair. It was fundamentally unfair, and I point to the supplemental record appendix that I provided this court this morning to show a couple of things, one of which I thought that the record wasn't very clear, the photocopy wasn't very clear. That would be supplemental record appendix number 1, and number 2, a phone calls that I had with my defense attorney on April 27th of last year, and a letter to PAWS, that's the Paris Animal Welfare Shelter. Paris, Kentucky is a historic, very old, thoroughbred based agricultural town, and it's more famously known as the home of Secretariat. This animal welfare shelter letter was inadvertently missed in the record appendix, and it was presented at the probation violation hearing. I want to get back to the purpose of this. The probation violation hearing, for which then resulted in a loss of due process. Sorry, I don't mean to be jumping around. The unfair hearing that resulted in probation conditions and a sentence, that sentencing judge, I believe, and as I argue, is important, like in Commonwealth versus Christian, to be hearing a probation violation PVH hearing, especially if she's considering motions relevant to the conditions, as she was from May 2nd. Those motions had been in front of her since March April was heard in front of her on April 13th, and it was heard again on May 2nd, and it was under consideration when the first notice of probation violation was issued on May 24th. And what was the premises of that being issued? If you look at the docket, it's very clear that I was motioning the court on an emergency motion to travel. My benefits were affected. I had an appeal going on a false eviction in my home in Kentucky. Simply wasn't on the facts of that. I'm not going to bring that in here, but it was simply a frivolous eviction. So I was appealing that. My home, and I was a student, a full-time student, and I was registered for the University of Kentucky's full-time classes in that springtime when I was then sentenced. The sentencing, I'm surprised. I'm surprised that, in fact, the sentencing didn't result in probation that consisted of you must get all straight A's. You must do your public service by educating yourself. I think the premise of the foundation of probation is rehabilitation. Particularly, this state in particular is the foundation of the beginnings of probation. This is also the state that has the most academic institutions in this country, in this city in particular, per square foot. The fact that I was studying nutrition in animals, in agriculture, underlined that I was rehabilitating myself, educating myself for whatever other reasons that I had for finding housing and having a degree in Queen Sciences would help that. But it should have been incorporated into the sentencing, but it wasn't. What wasn't included in the sentencing was that supervision was required. What we have is we have at record appendix the probation violation notices, probation conditions, record appendix 82. Issued on January 11th. At the top, there is a check mark, but it's not in the box. It appears that this is a trifold carbon, and at the top is where you rip it off, and it must have been rolled or folded. However it was, I don't believe that was seen by the judge. It's not even in the box that it was checked off for supervision. The judge made it very clear what conditions of probation were. And I've provided this court with the transcript of that probation conditions hearing. The probation conditions hearing was very clearly articulated by the judge, and at page 29, probation on page, starting from page 26, the conditions articulated by the judge include nothing about supervision, include nothing about releasing ownership of very valuable titled animals that are used in my academic endeavors. In fact, the broodmare that I had out of Secretariat was found by me due to my background in knowing thoroughbred pedigrees, and by chance, like a lottery ticket, I was able to acquire her for academic purposes, for whatever future investment that she afforded me. She was 10 years old. That's a prime time for a broodmare with her background.
You're talking about the original conditions of probation?
The original conditions of probation.
Which were modified by Judge Minahan on the 17th of June?
Correct. Judge Minahan making that finding to change those conditions, where she, at the very beginning of the hearing, denied my defense counsel an opportunity to prepare. Now, what I find in the Commonwealth's briefs, which is surprisingly a misrepresentation of what clearly is articulated on the record, that my defense attorney, being served now twice, she was appointed on May 27th. We were served with notices. We had to go forward at that time with a preliminary hearing. That wasn't enough time. Then we were served on, we had a hearing scheduled for a final on that initial probation violation on 5/27. On 6/17, we were served with another probation violation and given no opportunity for 7 days according to the rules, the codified rules, Rule 4D, which requires 7 days to schedule a hearing. Judge Minahan, in the beginning, and this is very clear on the transcript, and the pages where that is found is page 18 and 19. The bottom of page 18, defense counsel says, I don't. The top of page 19 says, I'm not prepared adequately to proceed on the notice that was handed today. That's clear from the record. She was required to. Judge Minahan basically said, no, sorry, I'm not gonna give this to another attorney, and we were required to present. There was many documents to present for 4 additional violations, of which the Commonwealth presented on purely hearsay evidence. The progress report was one of the issues they brought up, and they presented that and purely presented by a probation officer named Melia.
All right.
Miss Melia. She had no reliable, credible anything in regards to substantiating that. She had no personal knowledge of it. She actually says in the transcript that she has not talked to the probation officer since the preliminary. That was May 27th. And now she's presenting on June 17th that we must go forward. She's violated conditions for failing to do a home visit. Failing to do a home visit is not part of the conditions. Scheduling it and allowing the probation officer in is, and the probationer wasn't at the door.
Your time is up. Thank you very much.
That's 12 minutes. I thought I was provided.
When the red light comes on,
15.
your time is up, and
Certainly.
it's on, and you're 2 minutes over. Thank you very much.
If I may just end, it would take me 10 seconds. I just want to make sure.
Go ahead.
Thank you very much. Appreciate that. The relief that I'm seeking is in the initial relief sought at the appellate level that was presented in its entirety to the single justice. This relief is immediate. Why is that? In Kentucky, there's a rule that you cannot proceed to recover converted property if you don't do it within a year's time. There's a statute of limitation there. I'm being prevented, basically found that I was in violation because I sought redress in the courts. I sought redress by reviewing the probation conditions and sought redress about my property that I was deprived a forfeiture hearing under 276 Section 4. I was never provided notice. I wasn't provided an opportunity to argue it. And now, while the judge, Canoni, was addressing that issue on all the motions subsequent to that, and she says, in specific, Mr. Gens, file an affidavit, and I'll consider about Ms. Erickson taking care of her animal property in Kentucky. But before judge could make that decision, I was violated. And after she made a decision, I filed a notice of appeal immediately. So this results. All I have done is tried to protect my property.
Okay.
All of my property.
Thank you very much.
Thank you.
Counsel?
Thank you, Your Honor. May it please the Court. Douglas Humphrey for the Commonwealth. I think what would be the best use of my time really would be to answer any of the Court's questions, although there are 2 points that I would like to make. The first being that I would suggest to the Court there is simply no evidence that the single justice, in this case Justice Smina, abused his discretion in any manner in his prior dealings with the appellant in this case. I would suggest to the Court that the record is simply devoid of anything suggesting any manner of bias shown to the appellant or anything of that nature, and I would suggest that argument simply does not lie. The other argument I would make that, although it was not addressed orally, is addressed at length in the appellant's brief, is that in this case I would suggest that a substitute judge, in this case Judge Minahan, can, under the rules of the court, hear a probation surrender hearing, that it need not be the original sentencing judge who hears that proceeding, although certainly that may be the case in some situations and perhaps is preferable in some situations. I would suggest that this court's own ruling in Commonwealth versus Goodwin makes very clear that a probation surrender violation hearing is in fact a new proceeding and can be heard by a separate judge.
Explain to me what happened on June 17th.
Your Honor, on June 17th it was the final probation hearing for violations that had issued in May. There was a preliminary hearing in May in which the issue of whether the, at that time, defendant would be detained. That hearing was held in May. Defendant was not detained. Probable cause was found at that point at the preliminary hearing to go forward, and counsel was appointed for the defendant. Counsel then continued the hearing one time to give her more time to take some photographs pertaining to one of the violations, actually a violation that ended up not being found by the judge, an issue that she was not found to be in violation. Counsel did some investigation on that. Then on
You say not found in violation, that's on June 17th?
Yes,
Okay.
exactly.
Okay.
Yep,
So what else happened on June 17th?
That did happen on June 17th. There were essentially 3 violations that the probation department went forward on, one being the issue with providing verification that the defendant had either completed anger management or would be completing anger management, one being an issue with paying probation supervision fees, and one being an issue with coming into contact with animals. In this case, the allegation being that the defendant had gone to the Sheriff's Department of Plymouth County maintains a farm stand that has animals on the property, and she had been to that area, although the probation department was never able to establish, and defense counsel was able to adequately argue that there was no evidence that she actually did in fact come into contact with animals, simply that she was at that
So that
farm
was
stand.
dismissed. That was
So that
found
was
not
she was
supported.
found not to be in violation,
Okay.
exactly. She was found to be in violation with regard to the supervision fees or failure to pay supervision fees, and with regard to the anger
And she was on notice when as to those violations? Back in May? I mean,
But I believe it was May 24th, if I'm not mistaken.
okay. So Ms. Erickson just described showing up to the hearing on the 17th and having new violations served on her?
There were new violations served on that date, that's correct. Violations pertaining to alleged ownership of horses in Kentucky, which would be potentially a violation of her conditions not to own or possess, come in contact with animals. The Commonwealth would take issue with the representation that Ms. Erickson was forced to go forward on that day, and I would suggest the record would bear out that Judge Minahan, after finding the original violations that had arisen back on May 24th, was going to hold another preliminary hearing, as is the process, with regard to detention on the new matter. She spoke to counsel. Counsel, I believe, did say, I'm certainly not prepared to argue fully the issues involved in that hearing. And I would suggest the record would bear out that Judge Minahan said, certainly, if you need more time, you may take that time. If you need time to investigate these other issues, you certainly may do so. However, if you would like to speak to your client, if she has the inclination to admit to this new violation today, I would not be seeking to further punish her. In a sense, she would have a concurrent sentence, that sentence being a 30-day house arrest. It was going to be a 30-day incarceration period. Counsel was then able, again, to persuade the Judge Minahan not to incarcerate her, but rather to employ house arrest.
So what was the disposition on the newly noticed?
It was 30 days of house arrest. It was also clarification on her conditions of probation, specifically clarifying what contact Ms. Erickson could or could not have with animals, because although there was no violation found with regard to her visit to the farm stand, it was of concern given that there were animals on the property, and Judge Minahan sought to clarify those conditions at that time.
So there was a finding of violation on the newly noticed one as well?
I believe there was, yes, Your Honor. I believe
And
she admitted
you're saying
to
that
violation.
was with the consent or with the agreement of Ms. Erickson?
After, I believe there was a very brief recess, counsel and Ms. Erickson spoke, and then that violation was found, and again, there was no additional
Okay.
sentence imposed.
The violation was found or agreed to?
It was essentially agreed to, yes, without going through the full hearing, exactly. We did the full hearing on the allegations that arose on May 24th, and then this newer allegation was admitted to.
Okay.
I would also suggest to the court that there was a full and fair hearing at that time. The appellant was represented by counsel. Counsel presented, I believe it was one civilian witness, as well as her investigator. She also presented exhibits at that time, and I believe the appellant, at that time the defendant as well, testified in her own behalf at that hearing, the conclusion of which, as you've heard, Judge Minhan did make the findings that she made, that there were violations with regard to anger management, there were violations with regard to community service, and there were no violations at that time with regard to contact with animals arising from that earlier incident.
Can I ask, I'm sorry.
Well, I just wanted to ask whether the no travel is connected to the fact of the violation?
The no travel is not connected at all. Essentially, the no travel is not in any way connected to probation. It is, for lack of a better word, by operation of law. It's a result of the interstate compact. In order for her probation to be transferred to Kentucky and for Kentucky to accept it, she must demonstrate residency there and comply with those residency requirements that Kentucky has. Because of her eviction, she's not able to do that, and therefore the probation simply cannot be transferred.
But she could go to Kentucky to try to clear up some matters.
She could with the permission of probation and with the permission of the court if she was to get a travel permit. She has applied for them in the past. They have been denied.
She have to get it from Kentucky?
I beg your pardon?
Who gives the travel permit?
The court here. The court here would do it because that's where her probation is located. It would be the Plymouth District Court.
You say she's applied for these, but they've been denied in the past?
That's my understanding, yes. I can think of at least one, if not more than one, that have been applied for, and I believe they have been denied in the past. There have also been motions to transfer the probation, and those, as I've said, by operation of law, have not been able to be accomplished.
Well, I understand the transfer part of it, and I guess the denial of permits to travel to clear up affairs in Kentucky are not before us, but
Correct.
I mean, it does seem that if her house has been foreclosed on and she needs to go to Kentucky to contest that, it seems to be a fair enough reason, wouldn't you think?
It may very well be. I know that some of those appeals have been, she has appealed some of those denials of travel orders in the past. I believe they have been denied on a mootness issue, essentially, because a lot of the hearings that are being suggested have come and gone by the time that these appeals are being heard by the court. I know that she has, at least, as I say, at least on one occasion that I can remember, applied for a travel permit. It was denied. But I believe the court is correct that is not necessarily before the court, but also certainly it may be reasonable to allow that if another application were made.
Okay. Any other questions? All right,
Thank you.
Thank you very much, counsel.
All right. Hearing